Hello, everyone, and welcome to Uncivil Law. I hope you are having a good day, and we are here again, despite my better judgment, with part two of Stupid Letter Time. I say despite my better judgment because part one was so stupid that, it kind of broke me a little bit. When the sitting judge wrote, and I'd like to read this again, this quote, the zealous partisanship the Republicans displayed in connection with the Garland nomination, as well as judicial appointments generally, reminds one of nothing so much as fire eaters, those fervent defenders of slavery who pushed the South into civil war. So the Republicans, in their zealousness dealing with the Garland nomination as well as judge nominations in general, are exactly the same as slavers. Read Nazis. And so we kind of broke down on Godwin's law at that point. And I looked a little bit into it because I was curious. Judge Lynn Adelman, who despite my assumption to the contrary, is a guy. He has been in office since 1997, and he was born October the 1st, 1939, which means he is 80 years old. So, although, of course, he has not announced anything formally as far as I'm aware, I would think that this might be, him, closing the door on his way out and saying, I'm going to start my own court with blackjack and hookers, basically, or retire or take on a position somewhere at an academic institution, presumably. Federal judges not infrequently leave the bench for other prospects. Personally, I don't know what it is. Maybe they just get tired or whatever, but people do leave the bench for other better jobs. So maybe he is in this category looking for a newer, better job, and this is his, farewell to arms, as it were, before he leaves. But we are going to continue reading because I don't know, I hate myself for something. So we are going to read more of this stupid letter, and we're going to pick up where we left off on page 14, and I don't know, I guess we'll see how far we get. So, maybe I should set up reward tiers for super chats. Like every $5 or something, I'll read another page. I don't know. We'll see how it goes. But here we are, where we left off with, states doing bad things because reasons. All right. Here is where we left off. Let's keep reading. It was utterly predictable that, freed from the requirement of pre-clearance, southern states and municipalities would once again enact anti-democratic laws designed to suppress or devalue minority votes. The court had to only pay attention to evidence compiled by Congress as well as long-standing connection between federalism and race, especially in the South. So basically, the entire concept of federalism is racially tinged. Okay, well, interesting idea. I understand that slavery permeated a lot of things, but I don't think the northern states were necessarily against the idea of federalism for whatever else they wanted. They're pretty happy with their own state level autonomy too, and they've been even more happy with it under the Trump administration. Somewhat ironically, the left leaning states have found out just how much they like federalism as they try to oppose the Trump administration. So it's a good reminder that federalism helps everybody. It would have been obvious to any reasonably well-informed observer, which of course implies that the people on the court who went the other way are not reasonably informed observers, I suppose, that striking down the pre-clearance rule would do great harm to the voting rights of African Americans in the South and to democracy itself. Nevertheless, the court forged ahead, not only exalting the notion of state sovereignty, which is a thing that exists as recognized by the 10th Amendment. Whether the 10th Amendment is a truism or not, it is still something that the whole idea between the 10th Amendment being a truism, by the way, is that it's already baked into the Constitution, so you didn't need to say it. So another way of saying that is that it's repetitious. So even if it's repetitious, that means it was there the first time, which means that, power not given to the federal government is given to the states. So even if you view the 10th Amendment as repetitious, then it just means it was there inherently. It's not like it disappears completely. It just means it was already baked in and we didn't need to say it twice. All right. Nevertheless, the court forged ahead, not only exalting the notion of state sovereignty, which again is not, a Republican concept, or I guess it is to some extent of very lower R Republican, but also reviving the equal dignity of states argument that arose out of the long disgraced Dred Scott decision. We're just going right to the wall, right? We're analogizing this decision under the VRA to the decision that upheld Dred Scott. That's good work. It had explicitly rejected in the South Carolina 1966 challenge to the VRA. Americans have been fighting since the Civil War and Reconstruction about structural implications of the events of 1861 and 1870 for sovereignty, dignity, and equality, especially the southern states. The implications of adopting equal dignity of the states, a former confederacy, as a constraint on Congress's Reconstruction power are profoundly troubling. Well, there is at least some idea there that if Congress is regulating the states, it should be doing so in a somewhat even way. And whether or not you adopt this idea or not, it does have some like intellectual merit, right? It should impose on all the states roughly equally. And I say roughly equally because different states have different demographics, different populations, different layouts in terms of cities and where the country is, and different density maps and different terrain and different all kinds of stuff, right? So you would want to adjust potentially depending on what kind of regulation you're doing for all this kind of stuff. But all else being equal, you'd want to treat them equally. That would be the idea, and seems to have some merit because this is a federated republic, right? These are sovereign countries, have become part of a federation that's tighter than the EU. So they're not what we consider countries anymore, but they still have some of that inherent sovereignty. So there is a pretty big idea there somewhere. Roberts' assurances that other sections of the VRA would help minorities turned out to be false. This became clear when the court decided Abbott, which the question was whether the Texas legislature had racially gerrymandered the state's congressional legislative districts so as to dilute the voting power of African American and Hispanic voters. The lower court engaged in intensive fact-finding and determined the state had intentionally discriminated based on race, a conclusion that set the stage for returning Texas to federal supervision under another section of the VRA. The Roberts Court reversal of the district court was a classic example of judicial overreaching. Maybe we should go reach Abbott on a future Supreme Court react and see if we agree with the conclusion, right? So are we actually going to analyze Abbott and why it is, or should we do it at some later point? First, deviating from usual procedure, the court chose to review the lower court's decision, even though the court had not actually entered an order providing injunctive relief. Okay, well, if there's a final judgment, the Supreme Court can review it, even if there's no injunction. So, okay. Second, the Supreme Court ordinarily reviews factual findings of district courts under a deferential clear error standard. That would be correct, yes. In Abbott, however, the court declined to apply this standard ostensibly on the ground the district court had mistakenly placed the burden of proof on Texas to show a lack of discrimination, a conclusion with little support in the record. Okay, well, that's conclusory yourself. Even assuming this is true, the normal court would have been for the court to remand the case so that it could apply the correct burden of proof. How the court, however, chose to describe the merits itself. I will agree with you so far as that is. The normal procedure is to let them do it in the first instance. But as we were discussing that Sixth Circuit case that's been bouncing around a couple times, every once in a while the court can come in and just say, well, we're not going to do that. We're just going to decide ourselves. So I don't know exactly what happened in the procedural history here to allow for this, but normally you would send it back with remand with instructions. That they chose to deal with the merits themselves rather than with remand with instructions is a bit odd, but it is something they can do. So, okay. In addressing the merits, the court also deviated from normal procedure. It ignored the voluminous evidence compiled by the lower court that Texas had engaged in intentional racial discrimination. Further, it directed the lower courts determining whether a state had engaged in racial discrimination to resume the state legislature acted in good faith, which, that does kind of make sense, all else being equal, because we presume as a general rule that laws passed are constitutional. Laws passed are constitutional is our default ground. We're looking for a constitutional interpretation. It's one of the very classic lower C conservative things that courts do is called avoidance. They try to avoid constitutional issues when they can. If there's a way to solve the problem without invoking the Constitution, they usually try. And so the idea that they were trying to do an avoidance issue seems perfectly normal to me. So here we want to assume the legislature acted in good faith, unless we can prove otherwise. That seems reasonable. Thus, even when the evidence made clear that in drawing legislative districts, white legislatures empowered white voters at the expense of racial minorities, they're entitled to a presumption of innocence. I'm not 100% sure that you, judge, understand how presumptions work and how evidence works. Those statements do not work in the same universe at the same time. If to go to a criminal law example, if you have evidence such as 10 eyewitnesses and videotape and blood and DNA and hair and signed confessions and planning documents and so forth and so on against a person for a potential murder, the volume of evidence that is against this guy, nevertheless, guess what? We presume you're innocent until proven guilty. We actually have to do that. So there's a lot of evidence, so it looks like that's probably going to happen. But when we start out the trial at step 1, the presumption is you're innocent. And then the prosecutor has to go, hey, look at these 10 witnesses and this videotape and the signed confession and the blood and the DNA and the hair and, all the rest of it. And then, that gets factored in. But yes, despite all the evidence in the world, you are entitled to a presumption of evidence. So these two statements don't go to the same world to me. You can have all the evidence in the world the legislature was biased. That still means they're entitled to a presumption. That's why it's called a presumption, because you're assuming in advance. You're presuming, right? Presumption? Okay, great. Oh, Lord. The upshot of Abbott is plaintiffs will face an almost impossible task in proving the states engaged in intentional racial discrimination with respect to voting rights. I'm not sure why that is. That we have a presumption says nothing about how hard it would be to overcome that presumption. Justice Sotomayor wrote a strong dissent, noting that both the Constitution's Equal Protection Clause and the VRA promises all citizens, regardless of rate, equal opportunity to participate in political process. Quote, the court today does great damage to that equal opportunity, she wrote, not because it denies the existence of the right, because it refuses enforcement. Well, we'd have to get a little bit deeper into Abbott to find out whether or not we agree with the decision of Abbott or not, because we don't have enough information here to reach a conclusion. It's treated in very summary ways, like, well, of course it's obvious. And at least to me, I don't read this and say, well, of course it's obvious. I don't even think, of course it's obvious, it's valid. I don't even read this and say, well, of course it's obvious, it's valid. Or, of course it's obvious and it's not valid. It's not obvious to me. There's not enough here for me to reach a conclusion one way or the other. I, of course, presume it's valid, just like I presume the legislature was valid. But, I've disagreed with U.S. Supreme Court decisions before. So maybe if we read Abbott, we'd disagree, or at least I would. But, we don't have enough here. Unfortunately, we've only begun to address the Roberts Court's decision assaulting the voting rights of poor peoples and minorities. Consider the court's 2018 decision in Hussett versus Phillip, which involved a massive Ohio voter purge purportedly carried out for the purpose of protecting the integrity. Again, federal law actually requires this. And yeah, I read this decision. I did read this decision. It's been a little bit since I've read it. So I can't quote you chapter and verse. Unlike the other one, which if I've read it, I've long since forgot about it. So the one she said Abbott, it's completely possible I've read that. If I did, I have forgotten everything about it. Okay? This one, I remember enough to remember the gist of it. And it surprised me it was 5-4. To me, the conclusion seemed perfectly on its face right. There was a federal statute passed that requires states to clean up their voting rolls. And it says something along the lines of, because I'm paraphrasing because it's been a while, but it says something along the lines of, if a voter who's registered doesn't show up for 2 elections in a row, the state is required to send mailed notice to the last place the voter was at to see if they still want to be registered. If the person checks yes and sends it back, they're registered. If the person shows up to the next election after the notice and votes, they're kept on the rolls. So it's only after the 2 elections and the notice and the failure to vote at the 3rd election that they're struck from the rolls. The logic of this being that they have moved. For example, I have moved many times. And although I have registered to vote many times, I have never once unregistered to vote, because I don't even know how you would go about doing that. So I don't even know how you would go about unregistering to vote. So my name is probably on the voting roll of half a dozen states. So this was meant to capture people like me to make sure that the rolls are reflective of reality. And, it seemed perfectly reasonable to me. So I especially in light of the Texas statute. So I don't know why it was 5-4, because it seemed right on its face. So this involved a massive Ohio purge. Read a purge that was specifically dictated by the statute. Purportedly carried out for the purpose of protecting the vote, as required by law. And Jan asked, can they register again even if they're stricken? Yes. So to Jan's question, yes, you can re-register to vote. It is just taking you off because it looks like you're not registered. But there's nothing stopping you from filing again and re-registering. So no problem. Yes, you can re-register. It's not a permanent thing. Ohio uses a voter's failure to vote as evidence the voter had moved and thus should eliminate from the voter list. The statute in question does, as I remember, say that you can't use a person's failure to vote solely to determine that they've moved. So you can't use that evidence alone. But you can, for example, send out a mailing as an additional something. So you can't just take note, they haven't voted so many elections in a row. You can't do that. But you can factor it in. So the statute does say you can't use it alone, but there's nothing saying, well, you can't do it with other stuff. The court declined to find that Ohio's purge of rolls from voting rolls violated the NVRA. Also, I'd like to take some note here that this probably directly impacted me personally, because I have been registered to vote in Ohio. So it's quite possible that this purge took my name off the rolls, which, isn't bad, because I can't vote in Ohio right now because I don't live there. So, just saying that among the many names that were struck by this, it could have quite possibly included mine. So there's that. According to the court, Ohio's purge passed muster because the purge was not triggered by the failure to vote, which was merely used as evidence. Right. The statute said, paraphrasing, you can't use someone's failure to vote as the sole piece of evidence. But you can use it as the basis to send out the notice, the failure to do one. So that was the rationale. Ohio, the most aggressive state, initially sends notice to registrants who don't vote for 2 years. If the registrant does not respond to notice and does not vote for 4 more years, they are presumed to move and purge from the rolls. Okay, fine. The problem with this procedure is that many people do not vote, do not respond to the move, and have also not voted. So you haven't showed up to vote for 6 years, and we gave you a notice about it. So, I don't know what to tell you. If they don't vote regularly, Ohio disenfranchises them, because that's what the law allows for, in fact requires. Further, they're not informed that they've been disenfranchised until they vote and they're told they're not registered. I'll take your word for it. It's been a while since I read the case. Voters of all stripes in Ohio were affected, but policy appears to be helping Republicans in state's largest metropolitan areas, according to Reuters. Yeah, voters of all stripes, including me. Me, personally. In the state's largest 3 counties that include Cleveland, Cincinnati, and Columbus, voters have been struck from the rolls in Democratic-leaning neighborhoods at roughly twice the rate as Republican neighborhoods. One can only presume it's because they vote more or respond to the notices or something, right? because we're sending the notices on the same terms to everybody. So if we're striking people in some neighborhoods more, it's because they're getting caught more. It's not biased. A 2016 analysis found Ohio removed at least 144,000 people from the rolls in African American neighborhoods in Cleveland, Cincinnati, and Columbus. Ohio is by no means alone. Purges are on the rise of the country thread the right to vote. And Unicorn Cupcake points out that it takes like 5 minutes to register a vote. Unicorn Cupcake is completely correct, because one of the things I did when I moved here was register to vote. And I did it by mail. And it took me like 5 minutes. Now, if we want to talk about me getting my driver's license and tags on my car, that was a lot more frustrating, let me tell you. But to actually register to vote, I printed off a 1-page form and I sent it in to the secretary. I did it like 3 days after I moved here. Not that it helped me vote because I moved within the window, but it was really, really easy. Also, when you go to the licensing for your car, when you go to get a driver's license or ID, they ask you if you want to register to vote as part of that too. It's called the Motor Voter Law. It was passed in the late 90s or something. So when you go to get your driver's license, they ask you, would you like to register to vote? It's on the form. Justice Breyer's dissent clearly explains the court's refusal to recognize the purge process is not triggered by the possibility the registrant has moved by failure to vote, which of course is precisely what the statute prohibits. It prohibits using that factor alone. It does do that, yes, but that wasn't what happened. Once again, it failed to Justice Sotomayor to say out loud what should have been obvious to everyone. The court's conservative majority was driven by a barely concealed ideological agenda, and the reading of the law entirely ignores the history of voting suppression against which the MVRA was enacted and upholds a program that appears to further the very disenfranchisement of minority and low-income voters that Congress set out to eradicate. Yeah. One of the other frustrating things about Texas in particular, and I did not know this going in, because I have been licensed to drive in, again, like a half dozen states, because I've lived in a half dozen states between like moving and all the stuff. And every time I've ever gotten my license to drive changed, they literally print it out at the center in question. So after your 2 hours of waiting and getting your eye checked and all the paperwork, blah, 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 they have special printers. They print it right on the plastic itself. They do it right there while you wait. And they hand you an actual plastic driver's license, your actual driver's license, and tell you nice. Did Texas do that? No. Texas printed me off a piece of paper, which sits in my car. It's a little irritating. Not for the least reasons, because now that I live here, and I'd like to go to like bars and stuff, I don't have a form of ID that has my date of birth on it anymore. So I have to carry around my passport, which is a little frustrating. At least I have a passport. She also explains how, and by the way, like at least in my neighborhood, every bar checks. Every bar checks in my neighborhood because there's a lot of underage. So they all check. So I actually have to have it. Even though I'm as old as hell, they still check. They wouldn't let me in the door. It's very frustrating. But that's what you do. The plastic one is being sent in the mail eventually, so Texas tells me. Eventually being the key word of that sentence. I think they said 4 to 6 weeks. Another Roberts Court's decision assaulting voting rights of the poor and minorities is Crawford versus Marion. In 2008 case, with the court upheld an Indiana statute requiring voters to present photo ID, which again, you know, I have like 4 different forms of ID, but only one that has my date of birth in it. And, you know, so yeah. Republican-run states have increasingly enacted such laws, arguing they're necessary to prevent voter fraud. The justification, however, is a sham. Who doesn't know how to get like ID? Who doesn't know how to like get ID or, you know, and they'll give it to you for free if it's for voting. The only type of fraud that voter ID laws is voter impersonation fraud, a person that shows up at polls pretending to be someone else, a type of fraud that almost never occurs. Yeah. No sane person would stand in line at a polling place and risk 5 years and $10,000 fine in order to cast one vote, which most certainly have no effect. People do occasionally vote in the wrong place. The degree to which they're doing it intentionally, who knows? What is not a sham, however, is that many poor people and minorities obtaining a voter ID is not easy. I've seen at least like man on the street type segments which, how reliable are those? Because they could be edited. But I've seen man on the street segments where they walk around in African American neighborhoods in, say, New York City and say, do you know how to get an ID? And no one understands the question. So I assume that African Americans are not infants and we shouldn't infantilize them. I assume they're adults and they can do this just like everyone else did, including me, even if it's a bit of pain. Many eligible voters live far from ID issuing offices and do not have access to a car or other transportation. Really? Moreover, such offices are only open on a part-time basis. Beyond the challenge of merely getting to the office, millions of these voters have trouble paying the fees that come with it because they're poor. The ID is free, by the way. Voter ID laws are like poll taxes, the type used in Jim Crow era that force people who do not have driver's license to obtain IDs solely for the purpose of voting. Thus, they discourage poor peoples and minorities from participating in political process. Justice Soter's dissent in Crawford explains why the Roberts Court decision was a mistake. He points out the statute threatened to impose non-trivial burdens on voting rights of tens of thousands of people, and a significant percent of them would be deterred from voting. Really? Yeah. And as someone else pointed in chat, you need ID for many, many purposes, such as buying alcohol, which is currently a problem I'm running into, and, buying cigarettes, because you have to be 21 for that too, and, getting access to government buildings and a whole bunch of stuff. So the idea that you need ID for a whole bunch, and cashing checks, which is, not an inconsequential problem for a lot of people who are poor, who, for better or worse, use payroll type facilities with massive interest rates, but they have IDs. Thank you, $5 from Greg Polanski. For $5, I appreciate it. It is very helpful. He went on to explain the state may not constitutionally burden the right to vote without making a particular factual justification the state had failed to make such a showing. If you say so. Finally, we turn to the court's very recent decision in Rucho versus Common Cause, which raised the question of whether state legislatures could constitutionally draw legislative districts to dilute the value of minority party votes. Yeah, this is one of them. The gerrymandering cases was Rucho, right? This practice known as partisan gerrymandering is a cancer on American democracy. I don't necessarily even disagree with you that that's true. I mean, that's an opinion, and I don't necessarily disagree with you. The problem was finding something judiciable. That seemed to be the problem the court was struggling with. Certainly was a problem Kennedy was struggling with for all those years. It enables legislatures to entrench the governing party, in Justice Kagan's word, against voters' preferences. Fair enough. The case before the court in Rucho, as well as other cases, made it clear to the court the legislature of both parties will go to extreme lengths to preserve and expand the power and subordinate voters of the opposing party. Computer technology and sophisticated data enable legislatures to pick voters who they want to represent them, rather than, as democracy requires, allowing voters to choose representatives who think will represent them. Personally, I'd like to have a law that says the nearest distance, not nearest split line, because that's a little bit funky, but there's a nearest minimum distance line. Anyways. Yeah. Nevertheless, in yet another 5-4 decision, the conservative majority on the Roberts Court held that partisan gerrymandering presents political questions that were beyond the reach. And here I will just pose to emphasize the problem that the court saw, okay? If you want to draw your lines for where legislative boundaries should be on the basis of race, that's not permitted in any degree, right? The 13th, 14th, and 15th Amendments have been interpreted to understand that racial-based drawing of lines is not permissible in any respect. So you can't do it for one person or 10,000 people or 100,000 people. You cannot draw the lines based on race. Okay? But here's the problem with partisan gerrymandering. The problem is that the Constitution gives the power to the legislature to draw the lines, which of course is an inherently political body. So the entire process is inherently political ab initio from the beginning. So politics are unavoidable. And so if you take the position that the legislature can't use politics at all to draw lines, you're like, what does that even mean? Because the legislature is political. That's all they do. The legislature is political. So to say they can't use politics in drawing the lines, it's or that doesn't make any sense. So they can do it to some degree. The problem is trying to find out the difference between a legitimate degree, whatever that might be, and an illegitimate degree, assuming one exists, and how you define the difference between the two. That was the problem. The court couldn't figure out. The court in its case law had sort of mused in dicta over about 20 years. The court in its case law for about 20 years had mused. It is possible to do it to some degree, and it's also possible to do it to a degree so far that it would be unconstitutional. And the court for 20 years said, please help us figure out the difference, and no one could. So that's basically the challenge. Nuvi gives me $5 and says $5 for ad block. Thank you, Nuvi, very much. The majority's rationale for reaching this result was what the court could not find a discernible and manageable standard. They couldn't find a judiciable standard for deciding when gerrymandering was so partisan as to be unconstitutional. Exactly, that was the rationale. Justice Kagan's dissenting opinion made clear how weak and unsatisfactory the majority's justification was. But in throwing up its hands, the majority misses something under its nose. What it says can't be done has been done. Over the last several years, federal courts across the country, including but not exclusively the district's decisions below, have largely converged on a standard for adjudicating partisan gerrymandering claims. The standard that they had come up with was very amorphous and very floaty and very open to interpretation. And when it comes to voting district cases and how these lines are drawn, the Supreme Court is in a unique position in terms of how it hears these cases. Okay, that also creates a problem. So in your normal run-of-the-mill average case, when someone is suing someone else, right, in federal court, what you normally do in your average run-of-the-mill court case is you start in district court with one judge who hears the case and does all the fact-finding, etc. Then you have an appeal as a matter of right to the Court of Appeals, which is the 3-judge panel, and then you can also ask for en banc, if you want, which is the entire court to sit, all the members of that circuit. And then you can further appeal from there on a writ of certiorari to the Supreme Court. So in your average run-of-the-mill case, the Supreme Court wouldn't be worrying about it that much. They wouldn't be worrying about it too much about, them not having a standard or it being a little bit shaky or whatever. Because one of the things the Supreme Court could do in your normal average run-of-the-mill case is let the lower courts figure it out, which is one of the reasons on which they take cert in the first place, is to settle disputes between the circuits. So one of the things they can do is say, well, we're not really sure what the standard should be, but we have a solution to this problem. We have a solution to this problem. Fortunately, we have 12 numbered circuits if you count DC, which you really should for the purposes of this exercise. We have 12 regional circuits. And what we can do is we can let each of them figure it out separately. So they can all argue amongst themselves for, the next 10 years or 20 years. And, they can have different panels and en bancs and blah, 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 blah. And they can all look at each other and sort of, compare notes with each other and look over each other's shoulders and copy and disagree and all that stuff, right? And so, once they have done that for a while, then what we, the Supreme Court, will do is use one of the classic grounds we have to settle a split of authority and resolve the problem. But fortunately, all these lower courts have already done all the groundwork for us. So we can now look at all the groundwork they've done, and we can go adopt one of those or modify them, whatever. We don't have to figure it out in the first instance. We can make them do it. Right? Okay, so that's your normal run-of-the-mill case. Why can't you do that in this case? Why can't you do it when it comes to voting district lines? Why can't you do it when it comes to how states draw the district lines? Why can't you just do that normal process? And it's because by law, by federal law, the normal process is not the process you use in voting district cases. The normal process isn't the process you use. The process you use in voting district cases is you file at trial court, but the trial court is a 3-judge court. The trial court is a 3-judge court. Okay? Don't ask me to explain it. I'm just telling you what it is, okay? So in voting district cases, when you file in district court and you get a 3-judge court. And then you have a right to appeal, a right to appeal, so to the Supreme Court, which is much different than a writ of certiorari. A writ of certiorari is discretionary. The Supreme Court has the right to say no, and they say no quite a lot to a writ of certiorari. But they can't say no to the appeal because they are the appellate court. They are the appellate court by law. They are the Court of Appeals. So they can't say no. And because they're the only Court of Appeals, there's no lower courts to help rough and tussle and battle it out and all that stuff. There's none of that to do. So all the Supreme Court can do is look at itself because there's no one else. It's just them. Because all districting cases are done this way. Because Congress said that. It's law. It's in the jurisdictional statutes. It's in the jurisdictional statutes. So when you're doing voting district cases, you can't, as the Supreme Court, say, well, what did the Court of Appeals do? Because it doesn't exist. You are the Court of Appeals. So you're the one who has to come up with this standard for the entire nation. You're the one who has to create this standard. And because every one of these cases can be appealed directly to you, and you can't say no to any of them, that means whatever standard you come up with has to be so easily understood that none of these appeals will go anywhere, right? You have to come up, because remember, you're appealing from the district court. And I don't even remember how many district courts there are. There's 140 of them, when you count all the district courts in all the states. 138 maybe, something like that. So you're going to have 138 appeals potentially every year on these cases. The Supreme Court can't deal with that. The Supreme Court can't deal with that volume. The Supreme Court can't adjudicate every one of those 131 cases. They can't do it. They just don't have the bandwidth to do it. So the only way for them to do it practically is to come up with a standard that is so objective, so clear, that, even a trained monkey could do it, right? And that way it becomes really, really easy. Because then it's just that the district court do the trained monkey thing. They just plug in the numbers into the equation so we don't have to consider these all the time. That's the problem. That was the problem the Supreme Court was trying to solve. So yes, the courts that had been dealing around with this stuff had come up with tests. The problem was the tests they came up with were really, really floaty and really, really discretionary and really, really sort of subject to judgment. And you say, well, what's wrong with that? What's wrong with standards that are really just subject to judgment? Isn't that good? Well, it's not so good when you're the U.S. Supreme Court and you're the Court of Appeals and you have to administer all these really, really floaty standards. And incidentally, by the way, lest I have to point out the obvious, if you're striking down a map, a politically drawn map, okay? You're striking down a politically drawn map. People are going to accuse you of politics, right? People are going to accuse you of politics. The courts don't do politics. The courts do law, right? But if you take a map and say, this map sucks, let's replace it with this other map that we created out of nothing, people are going to say, hey, you're playing politics. You're not supposed to do that. So the only way the Supreme Court can avoid that problem, is to come up with a test that is so clear, so objective, so easily administratable, and so unsubject to the whims of whoever's looking at it, that no one can accuse them of playing politics. It has to be an equation that you plug the numbers in and the result comes out and that's the end of the ball game. That's the only way this works, because the Supreme Court is going to be striking down political maps. So the only way for them to administer this, the only way for them to strike down maps, the only way for them to create entirely new maps and for people to people not to be able to say, well, this is just politics, this is just political, they're doing it to favor the Democrats or they're doing it to favor the Republicans. The only way the Supreme Court can be able to do all that with any sort of reliability, the only way they can do that is to have an equation that is so easy, a trained chimp can do it, and then it's aha, it's not politics because it's just the equation. That was the problem they were trying to solve. They couldn't do floating. They couldn't do discretionary. They couldn't be do something like, well, if you look at this way, or if you look at this way, then maybe it's this result, or maybe it's this result. They couldn't do that. They couldn't do that because then, depending on who's on the Supreme Court at any given time, the results are going to be different. So there's no dependability. As members of the court come and go, different courts are going to be coming up different results on the same facts based on the same exact tests, right? Because they're judges. They're judges. So as members of the court change on the same exact facts, they come out with different results. Now, that's not normally such a big deal, but it's a little bit of a deal when the issue at hand is, does this political map, should it exist? And if not, should we create a different political map? And we, the court, are going to create a new political map, and we want people to not think it's political. That's asking a lot, man. It's asking a lot. All right? So the only way I can see for that to possibly work, to create new political maps that are not perceived as political, the only way I can foresee that to work is we have something that's so dead simple, so objective, so clear, so unambiguous, that no matter who's on the court, no matter who's applying it, the result always comes out the same. Like a mathematical equation level of certainty. On the same facts, it always comes out the same. And the Supreme Court couldn't do it. They couldn't come up with something that clear. That was the problem. Okay? That was the problem they were trying to solve. That was the situation they were dealt with. They were dealt with a posture. They were dealt with a posture that put them into a position where if they're going to do this, it has to be so unambiguously clear that no one can doubt them. That was the problem. They're looking to the long-term legitimacy of the court. They're looking to make sure the court isn't perceived as political, because once the court is truly perceived as political, it's game over. And if we're going to strike down political maps and not be perceived as political, well, we need something super, super clear so that it doesn't matter who's doing it. That was the problem. And yes, I'm a little heated. Unicorn Cupcake. I'm a little heated because this judge, either it doesn't understand the problem, which I don't begin to believe for 1 second, because there's no way you can be a sitting federal judge since 1990 whatever and not be aware of the problem, or is not explaining the problem, or is being very disingenuous about the problem. It's impossible. It's impossible. If the court had gone the other way, and adopted the really, really floaty standards, then the Democrats would be even more irritated than they are now, because the Republicans who are currently in control of the court would then be using this really, really floaty test to create maps that would be perceived as Republican, and vice versa, depending on who's on the court. The institutional legitimacy of the court was on the line. Courts don't do politics. Courts do law. Right? So if we're going to do law and not do politics, and we're going to strike down political maps, and we're going to create new political maps, and not be perceived as political all at the same time, well, that's asking a lot. So the only way we can do that is for it to be completely objective, 100% no discretion, very, very clear, and they couldn't do it. And that's why the test that had been created by these lower courts that were really, really floaty, it had been agreed upon. The Supreme Court couldn't do it. They couldn't adopt it. It was completely unadministratable in a way that would have allowed the court to be legitimate. Completely unadministratable. So it had to be that way. So it really irritates me. Really irritates me. Because once you understand the posture of the Supreme Court, once you understand the mechanism of the Supreme Court and how this works mechanistically in terms of these cases getting before the Supreme Court, once you recognize that they have to hear every one of these redistricting cases, they have no choice, they have to do it. Once you realize that, it's like, what else can you do? And clueless beekeeping comes at me with a rejoinder. Says, sorry, Bob, but the court does do politics in the real world. Okay, clueless beekeeping. I accept your premise. the court does politics in the real world. All right, so here is your question then. Is that good or bad? Is it good or bad that the court does politics in the real world? If it's good that the court does politics in the real world, if you think the court should do politics in the real world, then it would be a good thing for the court to do politics. Therefore, this decision was wrong because the court could have done more politics. And it would be good for the court to do politics. So the court should have come out the other way because it would be good for the court to do politics. If, on the other hand, you think that it's bad for the court to do politics, then even if you accept the premise the court is already doing politics in other cases, it would not be a good thing for them to do politics in this particular instance. We should, if anything, roll it back so they're doing less politics, not more. So even accepting the premise that they do politics currently, unless you think it's good, this decision was correct. If you think the court should be doing politics, this decision is right because it is upholding a virtue. So even if they violate the virtue in other areas, we don't want to make it worse, do we? Okay? So even if you take the premise the court does politics, unless you think it's good for the court to do politics, then they shouldn't do this. That's what I say. Yeah. More significantly, the decision is profoundly anti-democratic. As Kagan's dissent put it, so the only way to understand his majority opinion is as follows. In the face of grievous harm to democratic governance and flagrant infringement on individual rights, in the face of escalating partisan manipulation whose compatibility with the nation's value and law no one defends, the majority declines to provide any remedy. For the first time in the nation's history, the majority declares it can do nothing about an acknowledged constitutional violation. And I just explained why they thought that way. That's why they thought that way. Thus, the Roberts Court's voting decisions made it much easier for the state legislature to prevent or discourage poor peoples and minorities from voting, which doesn't quite follow from what they just said, but okay. Further, it makes it harder for the plaintiffs' alleged racial gerrymandering to prove their case. Racial gerrymandering is a lot easier because it's always unacceptable to any degree. So it becomes a lot easier because all you have to do is find it in any degree, which again is a lot more administratable of a standard. Newbie gives me $2. Knox versus Lee, 1871. Was the court doing politics? Well, without me looking at Knox versus Lee, I don't know. But again, Newbie, it doesn't go to the issue, at least to me. Right? To say the court has done politics in the past, to say that they are too political now, doesn't tell me anything about whether this decision was good or bad. Because you're not answering the question of whether the court should be political or not. If you think that Knox versus Lee was wrong because it was too political, if you think other decisions are wrong because it's too political, then this decision was correct because it was avoiding politics. So even if they've made that mistake in the past, it's no reason to keep making the mistake, right? So, okay, Knox versus Lee was political. Premise accepted. Therefore, what is my answer? Is my question next? Right? If your argument is therefore the courts are in general political when they shouldn't be, okay, conclusion accepted. But should we not do that so that it would be less true? That'd be good. Governmental bodies can undermine democracy in ways others than restricting voting rights. If they prefer the government to be run by rich and powerful instead of ordinary citizens, well, yeah, because, members of Congress are, traditionally understood as poor. No. They can establish a politics to bring that about. The Roberts Court's decisions constitute such a policy in that they consistently augment the power of corporations and the wealthy and reduce that of ordinary Americans. Like the court's voting rights decisions, they undermine efforts by legislatures, judges, and activists to strengthen America. Probably the best place to begin discussing this aspect of the court's jurisprudence is its campaign finance decisions. Are we about to talk about Citizens United? Because if we're about to talk about Citizens United, I'm probably going to lose my crap because we've had discussions about it before. If we're about to talk about Citizens United, As animated as I just got about the gerrymandering decision, we're going to have a throwdown. I'm going to have to get up and get some bourbon or something because we're going to have a real big throwdown between me and the judge if that's where we're about to go with this. Okay, good times. Help me. This is because campaign finance rules a government adopts will go a long way in determining who gets elected and what policies were adopted. Counter evidence. C, campaign. Michael Bloomberg. The Roberts Court's campaign finance jurisprudence has substantially contributed to the creation of a system in which candidates become heavily dependent on the support of the wealthy. Even worse, it has turned the First Amendment into a weapon that prevents legislatures from altering the system. What? In 2014, in McCutcheon versus FEC, the court rejected for the 7th consecutive time a limit on electoral spending on the ground it violated the amendment. In McCutcheon, the court struck down the aggregated contribution limit, which capped the amount that a single donor could give to federal candidates and parties at $123,200 in cycle. McCutcheon confirmed the court using the First Amendment to block limits set by democratically elected officials on elected spending. And, those elected officials presumably have no interest whatsoever in the amount of money that, say, for example, one of their competitors could potentially spend on an election, right? Those limits were set purely from a pure place at heart with no consideration whatsoever on how it might affect the potential chances of a potential political rival, I'm sure. Even as the destructive consequences of the electoral system financially disproportionate to wealthy donors have become increasingly apparent. C, counterexample, campaign, Michael Bloomberg. The cases preceding McCutcheon include the following: Randall versus Sorrell, which held unconstitutional expenditures and limits set by Vermont; FEC versus Wisconsin Right to Life, which struck down federal statutes regulating sham issue ads. Attack ads artfully worded to avoid being treated as express advocacy and subject to regulation. Yeah, we're doing the magic words test, which is from a footnote in a case where we're only of course they're expressly worded because, Davis versus FEC, which invalidated the so-called Millionaires Amendment, a provision permitting candidates to face wealthy citizens funded opposed Citizens United. Okay, it's over now. Hold on. All right. It's over now. All right, we're going to do this. I'm going to do this. This glass is broken. Just by luck, got a broken glass out of the thing. Yep. All right. Okay. Hold on. Hold on. All right. Okay. Allow me to law-splain once again why Citizens United was correctly decided. Let me law-splain why Citizens United was correctly decided, and everyone who doesn't is a wuss. All right, let me explain this. All right. First of all, we need to go back to what the law was before Citizens United, okay? The law as it existed before Citizens United dealt with collecting of money by groups, which we would now call PACs and super PACs, right? So in essence, the law before Citizens United prohibited independent expenditure organizations, PACs, super PACs. It regulated how much money they could collect and therefore how much money they could spend, right? The law as it existed before Citizens United has nothing to do with how much a private individual can spend. So neither the law before Citizens United nor the law after Citizens United, and no matter which way Citizens United had come out, so neither before nor after, nor if Citizens United had come out the other way, would it have impacted Michael Bloomberg. Because Michael Bloomberg wasn't collecting money from people. But he was, but he wasn't, right? What he was doing was spending his own money. I'm sure he has some sort of donations, but that's not really the issue. He spent whatever he spent of his own money to run ads that were ultimately completely pointless, right? So the law before Citizens United, the law after Citizens United, and had Citizens United come out the other way, it would have nothing to do with really rich people being able to spend money. What it would have something to do with is not so rich people coming together to spend money as a collective. So what the law before Citizens United did was prohibit people from not from doing it, but it limited the amount to which they could do it. There was a monetary cap on how much people could contribute to these common organizations, and therefore how much they could spend. All right. All right. The titular Citizens United, the actual group, Citizens United. I forget if it was a guy or a group of people. I forget. But one way or another, it was an independent expenditure organization. And what Citizens United wanted to do was create a movie called Hillary, the movie, very creatively titled. They wanted to fund it, film it, and distribute it themselves out of their own pocket. And they wanted to put it on like pay-per-view on cable networks just before the election, right? I'm trying to remember exactly when this was. Was this when Hillary Clinton was running in the primaries against Obama? Because I don't think it wasn't when she was running against Trump. This was when she was still in the primaries against Obama. So this is going a little bit back now. But what they wanted to do is they wanted to film, distribute, produce, and put this on the air. And obviously that requires some expenditure of money. Fortunately, you can do all this relatively cheap. But you can't do it that cheap, particularly when you're talking about distributing it into theaters and putting it available on pay-per-view. You actually have to pay for that. And it was going to cost them too much money. So, if Michael Bloomberg had wanted to create Hillary the movie and do all this stuff, he could have done it at the time because he would be spending his own money. But this group couldn't do it because they couldn't collect the money to do it. And so they sued and said, hey, this is a violation of our First Amendment rights. And then people who have been endlessly misunderstanding Citizens United forever, excuse me while I have another drink. People who have been endlessly misunderstanding Citizens United forever have come away with two sort of memes, two meme statements. These two meme statements are that Citizens United said that A, corporations are people, and B, money is speech. Both these are kind of wrong. Okay, they're just wrong. First of all, Citizens United did not say corporations are people. The idea of corporate personhood goes as far back as the concept of corporations. It's not something that Citizens United created. The entire point of the invention of the corporate form was specifically to insulate people from the corporate form, so that people could come together for corporate purposes like buying, selling, making, whatever, and they didn't necessarily have to put their own money or their own livelihood on that line. Because the only alternative would be like where you as a person are completely indistinct from the corporation, which is still true today if you're a sole proprietor. You are the corporation. There's no legal distinction. But if you are a business of any size whatsoever, then your personal debts are not the same as the debts of the corporation and vice versa. So, to make an easy example, restaurants are a good example because they fail a ton. All right, restaurants are a reasonably good example. So you and your family want to start a restaurant. And if you take in a look at how often restaurants fail, you'd immediately decide this is a bad idea. But for reasons that pass understanding, you've decided this is a good idea and you're going to give it a shot. So you get some sort of initial investment of capital wherever that money comes from, and you put it into the business, and you can segregate the money from your assets. So, your house is not on the line. Whatever assets you have personally are not on the line. The only assets that are on the line are on the corporation. Now, you can, and a lot of people do, secure the assets of the corporation with personal assets, which is not a good idea because you've kind of defeated the entire point of creating corporations. So a lot of people will say, I'm going to back this corporate loan with my house, which is really dumb because you've defeated the entire point of having corporations. But if you're not that dumb, then, if your business then if someone slips and falls in your restaurant, if you go bankrupt, if you breach your contract, if whatever happens, then if you set this up correctly and you haven't commingled funds and so forth and so on, then your assets are not on the line. Your property is not on the line. Your house is not on the line. Your car is not on the line. The only thing that is on the line are the assets of the corporation. And, if they are exhausted, then they're exhausted and then the case is over because there's no money left. So you can't pierce the corporate envelope to get to the person behind it. Again, assuming that this was all set up correctly, there wasn't commingling of funds and so forth and so on, blah, 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 blah. But if you did this correctly, the entire point of the corporate form is to separate you and your money from the corporation's money so that you're not putting yourself on the line. So the idea of corporate personhood, what we mean by corporate personhood is that corporations as such can sue and be sued. That's what that means. And they can own property and they can sell property. They don't need a person behind it to do these things. The person behind it, of course, is doing these things. But the corporation as such, as an entity, can buy property, own property, sell property, enter contracts, make loans, blah, 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 whatever. That's corporate personhood, right? So the idea of corporate personhood goes as far back as the concept of the corporation. It is not something Citizens United created. Second thing, it is a misstatement, in my view, to say that money is speech. That is a misstatement. Because it's not, and it's absurd to think it is. It's much more accurate to say money facilitates speech. Because if I want to restrict your freedom of speech, there are two ways I can go about it. I can either pass laws that just restrict your freedom of speech, or I can create laws that inhibit the facilitation of speech, including, for example, expenditure of money. So, say, for example, the government wanted to prevent me from having a YouTube channel, right? They just want to prevent me from having a YouTube channel because they don't like me speaking. Now, one of the things the government might try is they might pass a law that says, you on civil law can't have a YouTube channel. Well, we're running into obvious First Amendment problems, right? Rapidly, we can't do that. But maybe they say, aha, what we're going to do is we're going to be a little bit more clever about it. What we're going to do is say we're going to limit how much money you can spend, and we're going to limit that amount to zero. Well, if we limit that amount to zero, then I'm equally out of luck. This microphone costs some amount of money. The camera costs some amount of money. The internet that it's running on costs some amount of money. So the cost of producing this is low, but it's not zero, right? So depending on what amount you set it to, you can limit my reach. And for example, should I want to run ads promoting this channel, that would cost money. If I want to put out flyers, or if I want to buy Google AdSense, or whatever it is I want to do, that costs money. So again, while the cost of this is low, it's not free low. And if what I want to do is create and produce a movie and distribute it in theaters and, run it on pay-per-view, again, that is not free low. So you can restrict what I can do, not by saying you can't say it, by restricting the means to say it. You can prevent me from creating a movie critical of Hillary Clinton, not by preventing me from creating a movie critical of Hillary Clinton, but by preventing me from spending the money to do so, right? So it's much more accurate to say that money facilitates speech. Whatever dollar amount you put on speech, means there are limits. Because, a lawn sign costs some amount of money. So that means that so many lawn signs you can produce. Bumper stickers cost some amount of money. So that's how many bumper stickers you can produce. If you want to do flyers or you want to run TV ads, it limits your money. It limits what time slots you can run it in. It limits what networks you can run it on, right? So to say that, if you limit the amount to 0, your speech is standing on the soapbox on the street corner. That costs nothing. But anything more than that costs some amount of money, right? So it's wrong to say that money is speech, but money facilitates speech is correct. And, so again, it's like, so should we have limits on it? And the answer to me is obviously no. We shouldn't have limits on it because any dollar amount you put on is a limitation on the facilitation. It means I can print this many copies of the newspaper, but not one more. It means I can print this many copies of the book, but not one more. It means I can make this many ads, but not one more. It limits my ability to reach. And of course, there's incentives all the way. So it doesn't make sense to limit it to anything. If what I want to do is create a book and self-publish it and put it in stores myself on my own expense. I don't need any stinking book company. I don't need HarperCollins. What I'm going to do is I'm just going to do it myself. I'm literally going to go and find a publisher and I'm going to write a book and I'm going to self-publish it en masse and distribute it to borders everywhere. Well, I can do that, but it's going to cost money. So why should HarperCollins be able to do it and not me? Right? Because the law has exempted media corporations. So why should HarperCollins be able to do this, but I shouldn't be able to do it, even though it's the exact same amount of money? Why should I not be able to team up with me and my 3 million closest friends to create a book if that's what I can do? And one of the criticisms against Citizens United was that money means people will buy elections. If we have unlimited money, people will just buy elections. Unlimited money is dangerous because people will just buy elections. And that's when I say, once again, see, counterexample, campaign, Michael Bloomberg. It didn't happen. And Trump spent less money than Hillary. And there are many, many examples where the person who spent less won. So it's not like you can buy elections. The entire premise of people who are opposed to Citizens United has not been borne out by the real world. So even though this person writing this says, hey, in the real world, this has been shown to be right. I'm like, I don't know what real world you're looking at, because the real world I'm looking at doesn't seem anything like that to me. So Citizens United was correctly decided. It was correctly decided on the First Amendment law. You should be able to spend as much money as you want because you should be able to have as much speech as you can buy. The idea that you have to buy speech is not a new concept. That's not new. The type of speech that you are buying today is a little bit different than in 1789, but the idea that you had to buy speech is just as the same. In 1789 and today, you had to buy books, buy newspapers, buy pamphlets. I assume they had some kind of lawn signs, so buy lawn signs, buy banners, buy whatever. That's true 1789 and today. The money facilitates speech. It is not a new thing. It is true the day the Constitution was written, and it's true today. The only thing that's a little bit different today is that you have additional things you can spend it on that you couldn't in 1789. In 1789, you couldn't buy radio ads and TV ads and internet ads. You couldn't do that because they didn't exist yet. But the idea that you had to spend money to facilitate speech, again, in 1790 and today, standing on the soapbox on your street corner is free. Beyond that, money has always facilitated speech. This is not a new or modern problem. You have a right to freedom of speech, but your ability to exercise that right is and always has been dependent on money. So, to me, it should be unlimited because the government shouldn't have the right to inhibit your freedom of speech. They shouldn't have the right to inhibit your freedom of speech by inhibiting your freedom of speech, and they shouldn't have the right to inhibit your freedom of speech by inhibiting the money you can spend to facilitate that speech. Either is equally censorshipist to me, and so, yeah. So that's Citizens United. I don't think it was wrong. I think the people who oppose Citizens United and have opposed it up to and including standing up in the Supreme Court and actively protesting verbally about how this was a betrayal of democracy. Well, again, C, counterexample, campaign, Michael Bloomberg. Money doesn't buy elections, but the government, or the people who are running the government, or the politicians who are in the government, have a somewhat notable incentive in terms of constraining the ability of people to speak, because it might help them keep their jobs a little bit longer. You know, the legislature did not come up with these ideas out of the pure whimsy of some sort of pure, unbridled American spirit. I think they probably came up with it with a little self-interest in mind, just a guess. All right. That was enough. Stephen asks me, how do you separate the free speech element from the ability to buy politicians? Well, I don't think you can buy politicians for the same reasons that I think I've said this before in a stream with Tactical, but I think the causality is the wrong way around. It's not that people are giving money to politicians to say things. It's because they say things that they're giving money to the politicians. So the causality is the wrong way around. You know, if say, for example, the NRA is a pretty notable group, pretty known to using its political speech, pretty known to spending money, right? If it were possible for the NRA to buy Nancy Pelosi, they'd do it in a heartbeat. But they can't. They can't buy a politician. But what they can do is they can give money to politicians who already support them, to politicians who already believe what they believe, and that's what the NRA does. The NRA is not going and buying people's votes. The NRA is supporting people who already believe what they believed initially. So the causality is the wrong way around. It's not that people are buying politicians. It's that they're supporting politicians who already say what they are saying. You know, that's how you or I would make a decision. Like, I don't know who you supported, if you supported anyone in the past election personally. But let's presume you gave $5 to Bernie Sanders or Andrew Yang or whomever. Why did you give them money? Because they were already saying what you wanted them to say, and you wanted to support them. Well, that's why the NRA, ACLU, Human Rights Campaign, NAACP, and everyone else is giving money to the politicians they give it. They're not buying politicians. They're supporting politicians who already say. So the causality is the wrong way around. It's not that they are saying it because they are getting money. It's that they're getting the money because they're saying it. The causality is the wrong way around. So that's what I think. All right, let's talk about Bertoli. Permitted corporations and unions to make unlimited expenditures. Same reason. It's a collective group. Arizona Free Enterprise Club and Bennett, which invalidated the triggering matching provisions of public finance. Again, when you are commingling public money, it comes in with some problems. $5 from Furby Slayer. This kind of goes with your free press idea. I agree. Money in the press are an amplifier. If the message is crap, it won't matter who sees it. Right. You know? And we don't even have to use politics as an example for that too. You know, there is a limit. There is a limit to what a marketing budget of any kind can do. And marketers will tell you this. If the product sucks, the product sucks. You know, there's a limit to what marketing can do. See, as example, like every failed product and every failed movie in the history of ever. Did all the marketing in the world save really shitty movies? Or did they fail anyway, despite all the efforts put out? It's like, you know, marketers can only do so much. If the product sucks, the product sucks. And conversely, or is that conversely? I think it is. Conversely, if the product is good, then even if you spend a relatively low amount of money, the product will spread. And you can see this example in movies too. You can see movies that had a very low budget or low marketing budget, but went on to be unbelievably successful because the product was good. So, you know, money does not buy support in products, politicians, or anything else. You know, it just does not do it. And people, again, people are giving money to the product, whether that's an actual physical product to the politician, because they like the product. People are giving money to the product, whether it's a product or a person, because they like the product. That's what's happening. Yeah. Ugh. After McCutcheon, the few campaign finance regulations that remain, the soft money ban, pay to play regulations. Well, pay to play is what we call bribes. So quid pro quo, right? Base contribution limits and even public finance systems are arguably at risk. Yes, they arguably are at risk. Probably not so much the pay to play, but the rest of it, because again, same logic, same restrictions on money. So, like, what is the problem, right? Yeah. Well, again, Furby Slayer, you're making my point as far as I'm concerned. Like, yes, Disney can buy out empty theaters to make their numbers look better than they are, but at the end of the day, the numbers are what the numbers are. Like, yes, this movie was super successful, but it was our money we spent, so it's not profit they enjoy. Hypothetically, Disney's purpose in making Captain Marvel was to make money. Hypothetically, that was their goal in life. So they made their numbers look good, but the way they did it was by spending their own money, which is then like they're paying themselves. So, like, what's the point? So, okay, it's been really successful because of sold out theaters. Well, we all know that that's not reflective of reality. They can try to say again, this is marketing, right? This has been sold out in theaters nationwide, but everyone looks at themselves collectively and like, no, it's not. Everyone realizes it's crap. Like, you can say, oh, we've sold out every theater, but everyone looks at everyone else and like, no, this isn't happening. So everyone knows it's a lie and it doesn't work. Nice try, but no, it doesn't work. And they can try to prop up the theaters, but at the end of the day, like, if it's a failed product, it's a failed product, right? There is a limit. Even Disney is only so big. Disney is massive. But even Disney is only so big. Even Disney can only do so much. And even Disney will eventually fail if they, are just spending money for the sake of making things look better than actually making it better. If Disney continues trying to do this, eventually it will catch up with Disney. It's a short-term solution, but eventually, and depending on what they do, it can be a pretty fast turnaround. So we're not even talking about like necessarily huge turnaround periods. Like, it could be that they do one thing one time and it crashes, right? So, like, even Disney, as big as they are, one day it's going to catch up with them. And it could be like a day where everything just comes together and it's the end. So, like, will Disney fail tomorrow? Probably not. But, like, will Disney fail 10 years from now? Could be. There's only so many times you can play that game before you're done. And even Disney will be done eventually if the product's not good. If the product's good, they'll last forever. If not, they'll fail. Disney can only play games for so long. Even Disney has limits. And if you don't believe me, all I have to do is point to like the Disneys of the past that no longer exist. The Fortune 500 companies that no longer exist. The movie studios that no longer exist. These businesses have failed. Everyone remember when AOL Time Warner was the biggest thing in the history of time? Yeah. Even huge businesses fail. Huge businesses fail. If the product's not good, the product's not good, man. There's only so much you can do. For only so long you can do it, man. There are limits. Kodak isn't quite done, but yeah, Kodak is a fair example, yeah. They've definitely been hurt massively, but yeah. You can. How many companies that were on the Fortune 500, say 50 years ago, are still around? This is like one of my criticisms of the left, or like Bernie Sanders or AOC. Like, they seem to think like these big gigantic corporations are big and giant and will be big and giant forever. I'm like, have you looked at an S&P 500 list from say 50 years ago and one today? I don't know how to tell you this, Bernie and AOC, but these really big companies, there's a better than not chance they will not exist tomorrow. Nothing, if you're not careful, because there's always someone behind you who's hungry, right? The big companies become complacent. It's a huge problem. The more power that you get, the more complacent that you are because the more market share you have. So you become more self-assured because you have more market share. I mean, this happened to IBM. IBM is still obviously around, but there was a time when IBM ruled the freaking world when it came to computers. And, they're coming back a little bit now today, but man, geez. It's like when you become complacent, there's always someone hungry looking to take away from you, and sometimes they do. So, like, who's big today and who's big tomorrow are not the same. Bernie Sanders and AOC seem to think like these really massive, like if Apple Computers doesn't think that they can fail and isn't spending every day trying to prevent themselves from happening, does anyone think that Apple Computers can't fail? Does anyone think Apple Computers can't fail? Does anyone think Amazon can't fail? Does anyone remember the Amazon of say 20 years ago? In other words, we'd call that Sears. Anyone remember Sears? The Amazon of 20 years ago? When they had catalogs and they were shipping things all over the country and they had stores everywhere and they ruled the freaking world. How's Sears doing today? Yeah. Anyone think Amazon can't fail? Anyone think that Amazon won't become a name that's forgotten as it becomes a bankrupt Kmart or Sears or JCPenney or Walsworth? Anyone remember these names? Anyone think Amazon can't fail? Anyone think Apple can't fail? You're not paying attention. Including potentially them. Capitalism is the best profit-making engine ever in the history of the world, and it is a game that everyone has to pay attention to because the big boys can fail, and they can fail rapidly. Massively. Someone else wants to be Amazon, I guarantee you. Someone else wants to be Amazon. If Amazon isn't careful, someone else will be Amazon. And we'll be talking about someone else tomorrow. Guarantee it. But the left doesn't seem to realize this for some reason, even though we're replete with history on it, which is very weird to me. It's like all we have to do is look at history. It's like these companies know they're on the precipice, man. They're always on the precipice. Some of the pre-Roberts Court finances cases recognize the government's compelling interest in combating corruption, which the court has treated as the sole basis for regulating spending, which could be construed as a compelling interest in combating the influence of money. Thus, for a time, Buckley v. Vallejo, the seminal campaign finance case, was not regarded as insurmountable constraint. Buckley v. Vallejo was wrong. But the Roberts Court has made it clear this is no longer the case. It never was. Yeah. Oh, Matthew, the right definitely has their blind spots too. The right definitely has their blind spots, man. Which is one of the reasons the right and left needs each other. One of the reasons the right and left need each other, because the right and left have their blind spots. Yeah, they definitely have their blind spots. Yeah, for sure. If they didn't, the right would never fail, and the right fails too. So we definitely have our own blind spots. Yeah. The court sees contribution and expenditure limits not as reasonable efforts to equalize political influence, but as an attempt to censor the voices of the wealthy. Well, it wasn't really the attempt to censor the voices of the wealthy, because I don't believe any of the cases this judge just mentioned. I could be wrong. But I don't think I am. I don't believe any of the cases the judge just mentioned did anything to limit the voices of the wealthy. It was always collective action, whether it was union or corporations or PACs or whatever. It was always collective. It was never individual. So the voices of the wealthy were never heard. So I don't know what they're talking about. Further, according to the court, the government's interest in safeguarding elections from distorting effects of corporate wealth is not only compelling, it's not even legitimate. Well, I don't think it's legitimate for a lot of the reasons I just said. Also, again, see counter example, campaign, Michael Bloomberg. Do I think at some point entities become too powerful? Well, I definitely think too big. I definitely think too big to fail should not be a thing. I have countless criticisms of the bailout and how that was handled. I don't really believe in too big to fail. That doesn't make any sense. I think the government's role should have been limited to some sort of chapter would be Chapter 11 bankruptcy as a financier of last resort for restructured bankruptcy. But I don't believe they should just give them finance cash. That was a mistake. I don't believe in too big to fail. If you make bad decisions, you should eat those decisions. And I don't believe the way we handled that was the right way to go. I do believe a company can be, the only real concern is monopolies, right? We're very concerned about monopolies. So if Amazon or anyone else is improperly restraining competition, then we have laws to deal with that. Antitrust laws, anti-competition laws. So yes, I believe in anti-competition laws. I believe in a free market. So Amazon can't inhibit their competitor. They can compete against their competitor, but they can't inhibit their competitor directly. That's the whole point of the free market. So yes, companies can become too powerful in terms of monopolies. Companies can become too powerful, and if they fail, they should fail. And if the government wants to provide a softer way of failing, then so be it. But the idea that that corporations that fail should be allowed to continue to exist is not capitalistic. So I don't know what that was from the Obama administration, because that was Obama with the bailouts. Not that the Republicans were particularly helping at the time, but that was not really a economic conservative thing to do. So I had many oppositions for that. I think there should be a free market, and if you fail, you fail. It's of course no surprise that campaign finance jurisprudence has led to an enormous increase in spending, most of it coming from the extremely wealthy. What's the problem? Court's judgments have also made American citizens far less equal in terms of ability to influence decisions. They had a lot of ability to influence decisions before. You're telling me there was some point in the past when your average Joe had a comparably higher ability to influence their elected official than now? I'm gonna have to see your work on that one. As Justice Breyer pointed out in dissent in McCollum, the First Amendment does not have to be construed in the extraordinarily individualistic way the Roberts Court has chosen. My brain stopped working because that sentence is dumb. My brain stopped working because that sentence is done. Dumb. The First Amendment does not have to be construed in an extraordinarily individualistic way. Okay. Another approach would be to consider the impact of the regulation on the body politique. For example, the reason we are concerned about corruption is not because it's a terrible crime per se, but because it undermines our belief in representative government. Corruption is not inherently terrible? Okay. And when elected officials are selected by and dependent on a small number of rich people, which I, again, dispute that because, again, without a base, all the rich people in the world won't help you. Trump did not win because of a small number of rich people. The same loss of faith occurs. Statutes that impose reasonable limitations. Yeah, the what constitutes a reasonable is going to be a very big problem, right? Yeah. Statutes that impose reasonable limitations, therefore, build confidence in the integrity of elected institutions. Nor do such statutes not violate the First Amendment. That they ensure that citizens are active and important in the part of self-governance project which American democracy represents. Yeah. Excuse me, I'm gonna sneeze. Excuse me. The Roberts Court has also placed interests of corporations above those of ordinary Americans. Take, for example, the decision in Sorrell versus IMS, which involved a Vermont statute prohibiting pharmacies from selling data regarding prescriptions without affirmative consent. The purpose of the legislation were to protect the privacy of physicians and patients, to protect doctors from being harassed from pharmaceutical companies, and to reduce the cost of health care by curbing disproportionate sale of expensive drugs. The law exempted academic researchers and nonprofits because they did not pose the same problems as representatives for the pharmaceutical industry. So, okay. So you can't sell data to some people, but you can sell data to other people. Okay. The court's conservative majority saw this different treatment not as a rational response to the marketplace structured by forces given the profit seeking actors, but as legislative interference with the marketplace. In the view of the Roberts Court, the marketplace is by definition a neutral and even benign space, which it is, that Vermont was contaminating by discriminating against particular speakers, pharmaceutical manufacturers. As in the campaign finance cases, the court treated government not as a representative of the public, but as a coercive force burdening the rights of corporations. I'd have to look into it a little bit more to really agree or disagree with this decision. I don't remember reading it, so I can't really give the same sharp rebuke that I gave for other things. So it's like I don't know if the judge is right here or not. So they might be right. It's just like I don't remember it well enough. Sorrell is disturbing on a number of levels. For one thing, the speaker was a large corporation. Why does that matter? As opposed to a small corporation. Why does that matter? Speech is speech. Whoever. And for another, the sale of data hardly seems recognizable as speech. Well, data is speech. It's just speech of a particular kind. For most of American history, law treated corporations as artificial entities created solely as economic instrumentalities, but always subordinate to public regulatory power, without authority to convert their state-enabled private wealth into political power and influence for speech. Those decisions were wrong. But as discussed, the Roberts Court has helped to change that. In Sorrell, the court treated a corporation's wish to sell and maintain data as superior to the individual's interest in privacy and in experiencing less expensive health care. The court also chose to shield corporations from democratic power, markets over majorities, if you will. Further, in commercial speech cases, the pre-Roberts Court, the court connected the protection of commercial speech to the formation of intelligent opinion and value of democracy. The Roberts Court has dispensed with the connection. I don't even know what that purports to mean. As stated, the decisions of the Roberts Court have not only augmented the power of corporations, but also reduced that of ordinary Americans, and this too undermines democracy because it exasperates inequality. Take, for example, the court's labor jurisprudence. One of the reasons the United States was able to achieve a relatively broad security and prosperity through the middle decades of the 20th century was the strength of ordinary labor. Well, press X to doubt, but that's more my political opinion than anything else. For contra example, I just point out like how the Japanese auto industry killed the American auto industry in the mid 20th century, largely because of American unions and the inefficiencies they created versus the Japanese model. So, press X to doubt on that one. Moreover, the more recent decline in fortunes of unions has operated to undermine the broad prosperity and sense of security that makes it marked for less group competition and antagonism. In a recent paper entitled Unions and Inequality Over the 20th Century, New Evidence from Survey Data for Economics, documents these facts. The paper makes clear that unions played a major role in reducing income inequality in the middle decades of the 20th century. And the decline since the 1960s has contributed significantly to the widening gap between the rich and poor. Both the rich and poor have gotten richer, I'd also like to point out. So, yeah. Only 8 more pages to go. Oh, thank God. You think we're going to make it? Should we do the other 8 pages now, or should we save that for another stream another day? I mean, we're at the bottom of page 26 with 8 pages to go. We could get a part 3 out of this. So, let's do part 3 because we're having way too much fun and we've been in an hour 47. Okay, so we're going to stop at the bottom of page 26. We're going to stop at the page of 26, and you guys will have to come in for the third and final installment of Stupid Letter Time. So yeah, you have to come back for Stupid Letter Time. Power through it. I don't know, man. I don't know. I will now take bribes to keep going. I'll now type Brobs to keep going. Let's see who wants to keep me going. Well, we can have competing Brobs. Who wants to contribute to make me keep going? Who wants to contribute to make me end? Yeah, only if I contribute to makes. Yeah, no, yeah. I have no problem. This is a corporate enterprise right here, right now. Uncivil law is a corporation, and wants your money. $5 from Greg to say keep going. Okay, Greg, we'll read a little bit more for Greg. We'll read a little bit more for Greg. Oh, man. Thus, a Supreme Court interested in strengthening American democracy might consider the wisdom of further weakening the labor movement. Okay. Sadly, this is not the Roberts Court's approach. Wow, they really want a different temperament of the court, man. Jesus Lord. No part 3, please. This is painful. Fair enough. Consider the 2018 decision in Janus. Oh my God, we're going to talk about the union free speech case. We're going to talk about the union free speech case of Janus. I feel like I need a different kind of alcohol or something. It's like I need to get up and get like a different glass of something else. Because now I have to lost blame Janus. Okay. Now I have to lost blame Janus. Consider the 2018 case in Janus versus American Federation, in which 5 conservatives overruled a 40-year precedent by eliminating a public sector's union ability to collect a fair share or agency fee from workers who chose not to become union members but are still protected. Just to make sure that we're all understanding what that just said, there was a rule, in fact a law, that required people to give money to unions, even if they didn't want to, even if they disapproved of that union's views and politics. So the workers had to fund the unions, even if they disagreed with the union, stuff like that. $10 for down your drink and keep going. Well, I'm not going to down my drink because it's bourbon. If I down this, I'm going to have a bad time. But I will keep going. As a result of Janus, public sector unions around the nation will no longer have to pay such fees, even though the union obtains benefits for them. Yeah. A recent study estimates the decision could reduce public employee union membership by 8% or over 700 million members. Well, that's people who don't want to be part of the union. So, okay, let me get this straight. Judge Adelman, who's writing this. Let me get this straight, Judge Adelman. It's bad that union membership is going to decrease 8% because 8% of people don't want to be part of those unions. So 92% of them like the unions, but 8% don't, and they don't want to give monies to them. But they should be forced to give money. They should be forced to give money to speech they don't like. That's a strange view of freedom of speech, but okay. Strange view of freedom of speech. Losses in membership will cause unions to lose revenue, and with less money, they will hire fewer representatives, take fewer cases to arbitration, and organize fewer members than they once did. Or, and this is just a thought, or, here's a thought. Hear me out, guys. Hear me out, guys. Or, they will have to work harder to be more representative of people so that people will want to be members of them and want to give them money. So they'll actually have to try because, their financial resources are on the line like a normal business. So, in the alternative, they might actually have to try to do things that the workers actually like. So those workers will say, yes, I want to give you money because you are actually working for me. In the alternative, they could try to gain back that percentage by not sucking as much. That's an option. Nor does the Roberts Court treat non-union workers any better than members of the union. Rather, the court systematically rules against both entities that represent ordinary Americans and ordinary Americans themselves. A good example of this, Who Wants to Bet is not a good example. How dare I bring logic into this? Well, it's like, I don't know what else to do. I'm just a logical guy. I'm just a logic. Yeah. At issue in Epic Systems were agreements employees had to sign as a condition of being hired that required them to give their right to join together with other employees to litigate dispute over pay and working conditions. Specifically, the agreement required employees to relinquish their right to bring class actions for back pay or damages and instead pursue their complaints individually before arbitrations. Well, this is more a problem with the Arbitration Act itself, which I would agree as a general proposition could use some work at best. I do think it's overly expansive, and I'm not really sure that Congress really had the current state of affairs in mind when it created it, because the Arbitration Act was created like, I want to say 1920 or 1918 or something. And so like it could use some work. So this is going to be a problem, not so much about unions, but the Arbitration Act, the Federal Arbitration Act, and the scope of it. So like if your criticism of this is that the Federal Arbitration Act could use some modification, I'm kind of with you. It's a law by Congress and it's been read in a very expansive way, perhaps too much so, and it's created some problems. And so, as a matter of policy, I agree with you. As a matter of law, I might even agree with you, but, I'd have to get really deep into the weeds of the Federal Arbitration Act, and I'd have to also be bucking a lot of case law because, again, this is not a new thing. Like, the court upholding and maximizing the FAA has been a bit of a problem. It is much more difficult, much less efficient for an individual worker to pursue a complaint than it is for a group. In employee class actions of that type, that Epic Systems arbitration agreements prohibited are means of dealing with an imbalance in bargaining power between employers and employees. But it's running smack dab into the Federal Arbitration Act. That's the problem. In Epic Systems, the employees sued the corporation seeking to recover overtime pay and to void the arbitration agreements. The Roberts ruled the 1925 Arbitration Act. Hey, not bad, because when did I say? Didn't I say like 1918 Arbitration Act? That's 1925. So I was on point. I was vaguely in the right neighborhood. That's not too bad. Hey, Obtuse One, thank you for joining me. Thank you for being part of the live stream. Thank you for being part of the Uncivilians. If you want to be one of the best Uncivilians, being one of the best Uncivilians can be accomplished with a super chat. Always appreciated. But thank you for being here. The Roberts Court ruled that the Federal Arbitration Act trumped workers' right to join forces in mutual aid or protection as provided by the NLRA, even though the NLRA was enacted after arbitration and therefore should have been regarded as superseding it. Okay, so a very, very brief word on this issue, right? Repeal, this would be what we call repeal by implication. Okay, this is called repeal by implication. So you have a statute, and then you have a statute later. Does the later statute repeal the earlier statute? If it says so, then obviously you're done. If not, then what you're trying to do is what we call repeal by implication. You're trying to say, okay, these two things cannot exist in the same universe, and so the later one supersedes the other one. Courts generally try to avoid this wherever possible. Courts try to avoid a repeal by implication. If it's inevitable, if it can't be done, then yes, they'll give the weight to the later one. So if they can't square the circle, the latter one wins. But the courts will try pretty hard to square the circle because repeal by implication is disfavored. It's disfavored because Congress knows how to repeal laws, right? The law is repealed, right? They know how to do it. It's not, it's not hard. So we assume that if they want to do it, they just do it. So if they didn't just do it, we assume they didn't want to. So yes, all things being equal, we'll try to square the circle, but we don't do repeal by implication. This guy seems to think we should do just repeal by implication willy-nilly or something. Yeah, so like, what's the difference between an implicit repeal and an explicit one? It's pretty easy. An explicit repeal says public statute whatever is hereby repealed. That's an explicit repeal. An implicit repeal is basically anything other than that. Yeah. The Roberts Court had already ruled companies could force consumers out of class actions and in arbitrations, yes. And Epic Systems did the same thing for workers. Again, I'm not sure Congress really had this in mind when it created the FAA, but yeah. Lawful is a bit dry compared to uncivil. Oh, no. Uncivil law is not meant to be in contrast to lawful masses. No. Well, I really shouldn't have said that out loud. I should have been more ambiguous about it. Okay, errata time. Okay, is uncivil law meant to be in contrast to lawful masses? Well, I don't know that I would necessarily say that directly, but it is a reasonable interpretation. So read between the lines if you like. Your old Grace says you never heard the term "square the circle" before. Really? Well, okay, but square the concept of square the circle goes as far back as the ancient Greeks. It was like one of the great mathematical puzzles to try to use nothing more than a compass and ruler to square the circle, which turns out is impossible. But yeah, the square of the circle is impossible in classic Greek mathematics, because in classic Greek mathematics, all you had was a ruler and a compass, so it was impossible. But yeah, it's like that's it's a like 3,000-year-old expression. Square the circle. Yeah. The case will have long-lasting implications for employees who use some $3 billion legally owed in wages every year. At oral argument in Epic Systems, Justice Breyer went so far as to say the case could undermine the heart of the New Deal. So there you go. By which it meant that the Roberts Court could, as it ultimately did, weaken one of the means by which ordinary Americans could maintain their incomes and sense of security. Finally, as the Roberts Court has reduced the power of unions and made it more difficult for workers to remain economically stable, it has treated the lower strata of workers and their very poor just as badly. In today's economy, the difficulties that the poor encounter in their daily lives are substantial, not to mention obstacles in ascending the economic ladder. This is where I would like to bring like facts into this equation. Okay, this is where I like to bring facts in this equation. The global amount of absolute poverty has been halved in like the last 30 years. The poor in America are comparatively richer than they ever have been and have more access to stuff, and their money goes further than they ever has been. And things are collectively cheaper than they ever have been. And up until 2 days ago, minority unemployment was at an all-time low. Woman employment was at an all-time high. The economy and stuff was booming, and then contra-virus. But up until that point, I don't know, man, things were looking pretty good on the numbers. But unemployment was at a record low. Black unemployment was at a record low. Minority unemployment was at a record low. But that's just like numbers. Okay. In its 2017 annual report on the poor, the Census Bureau indicated economic recovery had bypassed many of the 40 to 45 million Americans living below the poverty level. Well, it might be too soon, and I'm not sure exactly what they're saying there. Moreover, since 1975, the percentage of families living on income no greater than half the poverty threshold has nearly doubled. Really? Okay. This is because government policies designed to address poverty are highly inadequate. The decision of the Roberts courts, however, are quite indifferent to the poor. Consider NIFB versus Sebelius, in which the court thwarted Congress's effects to address one of the most serious problems, the lack of health insurance. Deep breaths, Kurt. Very deep breaths. By determining the Affordable Care Act's expansion of eligibility for Medicare exceeded Congress's power under the Constitution's spending clause. Swing low, sweet chariot. Okay, let's try this. The Roberts Court said that the Affordable Care Act did not pass muster under the Commerce Clause. And thank God for that, because God knows that thing had been extended so far. We all know what I think about Wickard v. Filburn, right? We all know what I think about Wickard v. Filburn. A unanimous decision from the U.S. A unanimous decision from the Supreme Court, and what crap that is, right? We all know what I think about that. And so, like, does the Interstate Commerce Clause include the ability of the government to require you to purchase stuff? No. Thank God for that. Wow. I mean, the left, I mean, and I think this is a fair characterization. The left really loves the Interstate Commerce Clause because it gives the government so much power. They love government power, man. They want this thing to be infinitely flexible. I mean, they wanted to ban guns using the Interstate Commerce Clause. That would be Prince v. United States, by the way, is the case. In case you think I'm making it up. You know, it's like they want to do a lot of things with interstate commerce. It's, you know, so the fact that they find limits somewhere is amazing. I think Wickard should be overturned. Please overturn Wickard. Let's overturn Chevron first, because that's more likely, and then we'll overturn Wickard. In which the court thwarted the efforts to address one of the most serious problems the poor face, the lack of health insurance, by determining it exceeds the spending clause. Congress expanded Medicare, a federally financed state administrative program, to achieve the ACA's goal. Do I have to law-splain this one too? Okay, let me law-splain this too. In expanding Medicare coverage, they put on additional terms and conditions on it. The states didn't want to adopt the additional terms and conditions. And the Supreme Court said, hey, these are actually additional terms and conditions. Like, if you accept federal money, as a general rule, the federal government can tell you how to spend the money, under what conditions to spend it with, because it's their money, right? So they can say, here's a big pile of money, and here are the terms, conditions, limitations that come with this money, right? So the states had previously accepted Medicare with the terms and conditions that applied at the time. They were willing to accept that deal. And then as part of the ACA, they wanted to expand Medicare, but they also changed the deal. I mean, Lord Vader style. Pray I don't change the deal any further, right? And so what the United States government argued is, well, you already accepted the deal, so you can't unaccept the deal. And what the states said is, yeah, but we accepted it with these other terms, and you're trying to impose it. And the court said, yeah, these are other terms, and you can't impose it. So they want to shove additional terms down their throat that they never deal. So this, like, let's modify the contract. This would be like you and I have a contract, right? You and I have a contract. You know, I'm going to give you $10 and you're going to give me 5 widgets, right? That's our contract, right? And I say, okay, now I'm going to give you $20 and you have to give me 10 widgets. And you say, but that wasn't our deal, right? It was 10 for 5. And I say, but I'm changing the deal and you have to. And you're like, what? No, I don't. That wasn't what I agreed to. It's like, yes, but you agreed 10 for 5. And that's the same thing as 20 for 10. And you're like, not to me, it's not. I don't want this deal. It's like, you must take the deal. You must take the deal. You said 10 for 5. Therefore, you must accept 10 for 20 for 10. And you say, no, that's not what I agreed to. And I say, ha ha ha, you must take it. Okay, that's basically what happened. You know, very simplified, but yeah. You said you would sell me your house for $400,000, but I have $410,000. Therefore, you must also sell me your car. No, that's not what I agreed to. All I agreed to is selling the house. No, but you have to sell me your car now. Also, you have to sell, like, your daughter's house to me. But that's my daughter's house. No, but you have to sell that to me too. I'm going to give you money for it, though, so you have to. You're obligated because you agreed. When do I agree to this? Well, you agreed to it when you signed the contract. But the contract doesn't say any of these things. But that doesn't matter. You have to sell me all these things now, too. What? What? I've altered the deal. Pray I don't alter it any further. Yeah. Congress expansion for eligibility for Medicare was the way they chose to balance it. The ACA provided federal government would pay for 100% of the costs for the first 3 years, gradually reduced over the following, and 90% from 2010 thereon. Yeah, but that's still 10% the states had to pay that they didn't before. So yes, it's like, yes, we'll pay 100% for 3 years, and then you have to pay 10%. But I don't want to pay 10%. But you have to pay 10% because you agreed to accept the money. But I don't want to accept the money. But you agreed to accept the money before. But I didn't have to pay 10% before. But you agreed to accept the money, so now you have to pay 10%. But that's not fair. That's not what I agreed to. But you have to. Yeah. Okay. I'm having too much fun with altering the deal. Sure. To encourage to encourage states to participate. The law provided that a state refused to participate, it would lose all or part of the funding. Yes, that would be encouragement. Yes. The Supreme Court's decision holding Medicare expansion unconstitutional was a surprise. Congress's spending power is very broad. Yes, Congress can spend money the way it wants, but it can't impose conditions on states. We've covered this. You can't impose on the states like that. It's improper. We covered that in the gambling case. The reason the gambling's now legal in some of these states. It's considered commandeering. The federal government can't commandeer the state legislature. They can't do this. So yes, Congress can spend money, but not to the point that they make the state do stuff. The Congress may be able to make the state do stuff for other reasons. There's a lot of other things that require the states to do stuff, right? So make no mistake, there might be other provisions of the Constitution that allow Congress to impose on the states. But one of the things is not the spending power. They can't impose on the states with the spending power. So yes, they can spend money any way they want, but the person has to accept it. Incidentally, that's the deal in every contract and gift for that matter. A gift to be valid has to be accepted. You can refuse a gift, you understand, especially if it comes with strings, you might not want to accept it. So I can't force you to accept a contract and I can't force you to accept a gift. You have a right to refuse. So, there's that. The breath is captured in the words to provide for general welfare of the United States. That's the preamble, isn't it? Okay, no, it's not. I'm just checking. Moreover, the court had previously interpreted the spending clause broadly. Yes, I'm not sure we're necessarily disagreeing. In fact, it had been close to a century since the court had found Congress has exceeded spending power. The court's reasoning was also surprising. Chief Justice Roberts opined Congress exceeded spending power because it coerced the states into participating by authorizing the withholding of funds for existing programs if they refused to participate. Yeah, they were trying to alter the deal. Before NFIB, no federal court had ever found any legislation to be unconstitutionally coercive exercise of spending power, although it was implied, at least in South Dakota versus Dole, right? Which is the reason that every state has a drinking age of 21, because if you make it anything less than that, it comes with 10% of your highway funds. So it was implied there were limits in South Dakota versus Dole, and they found one. So fine, makes sense to me. The Roberts Court, however, was not deterred. Further, as a remedy, the court rewrote the ACA to prohibit Congress from withholding funds, thereby removing the incentive they had created to encourage states to provide health care. Well, they also don't get the new money. That is also part of the deal. So they don't get the more money, so they still have an incentive. So it's wrong to say that they removed the incentive. The incentive is still there. The incentive is you get more money. And it comes with more conditions. Whether those conditions are acceptable to you or not is a whole bunch of things, right? Robert's explanation as to why Medicare expansion was coercive is unpersuasive. Okay? Persuade me. His major error was to say that by expanding Medicare eligibility, ACA had changed Medicaid program so dramatically as to transform it. That is to quote you from your first sentence of your paper. That is disingenuous. It is not, Roberts didn't say that the expansion of eligibility was what changed the program. That wasn't the problem. The problem were the things that came along for the ride. So you are being disingenuous. Roberts didn't say the error was the expansion of eligibility. That wasn't the problem. The problem was the additional things it imposed on the state. That was the problem. This conclusion was critical to the coercion analysis because it enabled the court to rule that because the expanded program was a new program, the possibility that Congress might withhold funding from the old program constituted a condition unrelated to the expanded program on which they were spending money. Okay. The court's rigid distinction between a new and old program is extremely artificial. Well, any line will be artificial at some point, so okay. Unless you think there should be no line, which seems to be your implication. Apparently, there is no line to you. The basic function of Medicaid, both before and after the expansion, was the same: to provide health care to poor people. Yes, that's a little reductionist, especially when you look at it from the state's perspective. When Medicare was created in 1965, it provided certain categories of the poor, such as elderly, blind, and the disabled. Since then, Congress has amended the statute many times for the purpose of expanding eligibility to other categories, such as children and poor pregnant women. In the ACA, Congress further expanded the program to make it available to non-elderly. In other words, there have been a clear continuity in changes made to Medicare over the years, gradually adding additional categories of the poor. But I don't think it imposed any additional burdens on the state. I could be wrong, but that would be the other half of this analysis that you're not speaking to. Right? Congress had added additional categories to the program. The question I want to know the answer to is to what extent, if any, did those impose additional obligations on the states in terms of their financial obligations? That'd be the answer I'd want to know, which you seem to not be mentioning. Moreover, when Congress limited eligibility in limited categories at the inception, obviously did not intend those to be hardwired constraint to protect states from the possibility it might add other poor people in the future. Again, I'd want to know what, if any, additional obligations necessarily came with those additional categories. That'd be what I'd want to know. The ruling has proved catastrophic for the most vulnerable Americans. By making it easy for states to decline, the court reinforced the discrimination against the poor in the South. Okay, sure. A legacy the United States has been trying to overcome since the Civil War. As the court's decision in Shelby County gave Southern states a green light to how much longer is this thing? I want to end. I want it to be over. I want it to be over. Southern states greenlit to renew their long-standing pattern of discrimination against African American voters. So too, NFIB encouraged Southern states to continue after a long-standing tradition that is severely restricting social service benefits to their poor citizens, most of whom are African American. After the court decided NFIB, the consequences of the decision did not take long to emerge. Numerous states, now totaling 19, including every former state of the Confederacy except Arkansas and Louisiana, refused to participate. In 2016, Louisiana aired the program after electing a Democrat governor. That would be politics for you, right? That'd be politics. So that would be politics, which is fine, right? The people of the state elected different people, made different decisions as part of the political arena and policy. Do I have any objection to this? No, I do not have any objection to this. This is fine. Okay. Oh my God, I see conclusion at the bottom. There's hope. The decision has caused at least 2.6 million Americans who have been eligible to not receive them. 91% of these Americans live in the South. In fact, more than half the adults falling into the coverage gap lived in 3 states, Texas, Georgia, and Florida, and this group, a vastly disproportionate share of people of color. Naturally, this has had significant negative impact on people's health, and once again, the Roberts Court strike a mighty blow against government effort to provide equality. And thank God we have reached conclusion. I mentioned previously I'd like to provide additional comment regarding how the Roberts Court's decisions I have discussed have harmed democracy. It's not difficult to understand how the Court's decisions concerning voting rights undermines democracy. Rulings that discourage people from voting or place obstacles in the path of voting have caused people not to participate in decision-making process that is the essence of democracy. Undoubtedly, large and influential sectors of the population have always opposed democratization and the extension of political rights. $5 from Brian Yoder. Thank you, God. Sorry for extending your misery. Down your drink and end the reading, or don't, your choice. Thank you. Thank you, Brian. Sweet Jesus. I have to say that, bourbon made this very possible. So God bless the framers of the 21st Amendment. Yet one would hope the Supreme Court would not be among them. The court, however, has constantly ratified the efforts of Republicans to accomplish precisely these purposes. Further, as has weaponized the First Amendment to combat efforts to democratize the law of campaign finance, the court has weaponized the doctrine of states' rights. Oh, my holy Lord. Oh, my holy Lord, please, God, have mercy on me. To prevent Congress from dismantling obstacles that minorities encounter in voting. Instead of doing what can be ensured to maintenance of a robust democratic republic, the court's decisions ally with the most anti-democratic currents in American politics, forces that would be pleased if unlimited money could be spent on elections and if minorities could be deterred from voting. Well, holy Jesus, man, we're just assuming the worst possible about our Republican brethren over here, aren't we? Jesus, holy Lord, we are just assuming the Republican Party at large and conservatives are just a bunch of evil assholes. Jesus, Lord Christ. But you did compare us to slavers earlier, so I guess there's that. So, Lord. The anti-democratic nature. Yeah, please, Matthew, don't write like this. I do not consider this to be particularly great writing. I wouldn't necessarily copy this in your writing. The anti-democratic nature of the court's decision, weakening the middle class by augmenting corporate power and reducing that, is perhaps slightly less obvious. However, scholars have shown that a strong middle class is essential to a thriving democracy. In the book, The Crisis of the Middle Class, The Crisis of the Middle Class Constitution, Ganesh Sataraman talks about how when the founders of the American political system developed a constitution, American systems were relatively equal economically. That is BS. There's no way. I'm pretty sure there were rich people at the founding of the country. Compared with England and other Western economic countries in the late 18th century, Americans didn't have either super rich tiers or a bottom rung of the desperate poor. American estates were minor compared to that of English counterparts. George Washington's estate, for example, earned £300 per year in the 1770s. That would have made him the better sort of yeoman in England. Okay. The lack of a wealthy elite extended to the merchant class. The wealthy urban American merchants were worth £25,000 to £50,000. Their counterparts were worth £200,000 to £800,000. Without knowing the entire economic demographics of the two countries, doesn't tell me anything. The contrast is equally true at the lower end. Conditions approaching slums were unknown in America. Really? During an economic downturn, 10% of the American population might be poor, but it's a far cry from the 50% of the people in England who are occasionally or relatively relied on charity for survival. I would imagine, all things being equal, that the people at the founding of America were all relatively rich, because all of them had to get on a boat and come over here and would have assets and stuff. So, I'm sure they were comparatively more economically well off, to be able to do those things. So, sure. America in 1774 was surprisingly egalitarian. Considering all households, including slaves, the top 1% had 85% of total income. When only free households, the numbers dropped to 7.6%. By comparison, the top 1% of Americans took 19.3% of total income. Matthew says that's not actually correct. A lot were indentured servants. I'm sorry, Matt, but I honestly don't even know what I said at this point because I've been reading a little bit. So, I'm not sure which point you're trying to contradict. So, where I said they were all relatively rich, a lot more indentured servitudes. Okay, fine. Sorry, it took me a little bit longer to remember what you were responding to because I had lost the thread. $5 from Nuvi, thank God. Serious question. Can the obvious bias presented in this review be used to initiate impeachment of the judge? Well, I've taken the view before. I've taken the view as I've expressed that as far as I'm concerned, the House can impeach for literally anything up to and including because it's Tuesday and they're bored. That is my view of the Constitution. So sure, as far as I'm concerned, they can. But if I had my guess, I don't think this judge is going to be a federal judge any longer, or for much longer. I'd imagine this is a fart in the elevator and walk away kind of moment. This is the last pass before they leave the bench. So I'd imagine they're going to announce their retirement in the near future. That's what I'm guessing. Sitterman further explains the founders assumed that such equality would continue and base key provisions on the Constitution on that assumption. He also argues the country's ability to maintain relative inequality for 2 centuries has played an important part. As we've seen, however, all that has changed democratically. The condition of relative equality no longer exists. The foundation on which the Constitution was built, the existence of a strong middle class, and the absence of extreme wealth and poverty has substantially eroded. Further, corporations, wealthy, and those who represent them, adhering to advice expressed in the Powell Memorandum, which has been advanced more recently by a panoply, I do like panoply, of conservative activist groups. And, that's obviously bad. We don't want conservative activist groups like speaking and stuff. That's a problem. Refuse to support... Why is my camera chopping off the top of my head now? There we go. Refuse to support policies that promote common goods, such as Social Security, broad health care, and campaign finance reform. Why are they obligated to support those things? Are they not allowed to oppose those things? Is that not okay? Or what is it? Do you, maybe as a learned judge, you could tell me what opinions are okay for me to have under the First Amendment. Maybe you could tell me what it would be okay for me to believe and okay for me to think. Would you like to tell me what's okay for me to believe and okay to think? Because, obviously I don't know what that is. So if you could inform me what it would be okay for me to believe and what to think, I'd appreciate that so that I can be, I will no longer have wrong think. I don't know how all this wrong think has happened. I do have 3 college degrees and, a fair amount of experience and stuff. So I don't know how all this wrong thing happened, but if you want to tell me to not have wrong thinking anymore, please tell me what are acceptable views to have. That would be great. Rather, they use their resources to combat these types of policies and promote policies that benefit only themselves. They achieve considerable success in the selfish endeavor. We are thus in a new and arguably dangerous phase in history. Democracy is fragile, and even more so when government eschews policies that benefit all classes of Americans. We desperately need public officials who will work to revitalize our democratic republic. Unfortunately, the conservatives of the Roberts courts are not among them. It will definitely take every bit of democratic resourcefulness we can muster to undo the damage the court has already caused. And I thank sweet baby Jesus that we are finally done. We are finally done with this letter of stupid letter time. I'm just going to sit here quietly for just a minute while I fully try to comprehend this. So just give me a second while I sit here quietly to myself. Okay. $5 from Greg Polanski. Thank you, Greg, for your super chat contribution. All right. Well, I disagree with this letter. There were a few minor subtle aspects of this letter. I don't know if anyone was able to catch it. Because it was so there were so few and so minor that I'm not sure anyone really caught where I had disagreements. So I apologize if my disagreements were too subtle or not obvious, because obviously this letter was an exemplar, a bulwark, and any minor points are so small as to be unworthy of mention. So I don't know if anyone was able to catch the small errors I thought that there might be, but I did think there were just some slight points of error of reason, logic, special pleading, thinking through things from the opposite point of view, you know, reason, conception, just a couple minor things that, just a few little niggles that, I think, yeah, that was okay. So for the who suggested this letter? Matt, was this you who suggested this letter to me? Wasn't this you, Matt, who suggested this letter? I should ban your ass. That's what I should do. I should ban your ass. I should ban Matt. I'm not sure if I should praise Matt or ban Matt. Press F to pay respects to Matt, because Matt's not going to be here very long. Press F to pay respects. $2 from Furby Slayer. If you're getting wrong thing, be proud. Oh man, this is a good one, man. Oh, there's a part 2 letter? There's another letter? Is this the one that you sent me from Congress? Is that the other one, the Congress, the stupid letter? Or what is part 2? What is part 2? There's a part 2? What is part 2? What's in the box? What's in the box? What's in the box? Oh, Jesus Lord, it was a joke. Thank God. Oh, man. All right. Well, we will be on tomorrow. We will be on tomorrow with our regular recording, our regular streaming for our regular weekend recording. And until then, this has been Unsolvable Law. Thanks for joining me. Thanks for joining me with the bourbon. I hope this was as much fun for you as everyone else. Until later, my friends. Cheers. Cheers. And goodbye.